My screen is visible. I think it's better visible now.
Kamlesh, you can start. Yes, ma'am, the PPT is visible. Kamlesh.
My screen is visible.
Yes, ma'am. It's
Am I visible now?
Yes.
Yes. Shall we start? I'm waiting for command, sir.
yes, Kamlesh, you can start.
Good evening, everyone. I am Kamlesh Singh, and I'm the today's host for the today's session. I, on behalf of the whole team of Just Caucus, welcome you all for the today's session on the new criminal laws. Before we dive deep into the today's discussion, let me provide a brief introduction of Just Corpus and our eminent guest of today's session. Let me start by giving a brief introduction about Just Corpus. Just Corpus is a legal professional who have come together to bring up various aspects and chains of law under a single umbrella. Just Corpus is an edtech platform set up in 2020, has a wide reach of 600 clicks per month on an average basis on a website just www.justcorpus.com. The inspiration was derived from the ever-growing need for law students. Just Corpus has incorporated an interdisciplinary journal and a multidisciplinary journal as its subsidiaries, named as Just Corpus Law Journal and the International Journal of Law, Research, Education, and Social Sciences. Now, let me turn at a focal point of the today's session, the guest. Madam, we are privileged to have Miss Shivani Gupta, ma'am, as an esteemed guest speaker of this today's YouTube session. We welcome you, ma'am. About our today's guest, Miss Shivani Gupta, who is a law faculty at Kgk Pg College, Moradabad, UP. Ma'am is a distinguished legal scholar and educator from Moradabad, Uttar Pradesh. She holds a Bachelor of Law LL.B degree from Kgk Pg College, Moradabad, and a Masters of Law degree from IFTM University, where she was awarded the gold medal for her outstanding academic achievement. She has been actively involved in the legal academia as ad hoc law faculty member at Kgk Pg College, Moradabad. She has adjudicated international moot court competition and is a member of several international law associations, demonstrating her expertise and commitment to the field. As a research and enthusiast, she has contributed to various legal publications and conferences, showcasing her passion for legal scholarship. Her, her extensive knowledge and experience make her a valuable asset to the legal community. Her extensive knowledge and experience make her throughout her career. She has consistently demonstrated a strong work ethic, dedication, and a passion for excellence. Her achievement and contribution to the legal field are a testament to her exceptional abilities and commitment to the profession. Without further delay, I would like Miss Shivangi Gupta ma'am to take over the stage and provide you and please provide the valuable insight on this today's topic. Over to you, ma'am.
Thank you, Mr. Kamlesh Singh. Thank you, Just Corpus. Good evening, everyone present over here. So today, all we gathered here to discuss some of the very important aspects that is being in the news since 1 year, but now it's a very breaking thing for each and every person. Either it's a Aam Aadmi person, either it's a law student, or any of the person belonging to any law fraternity in the form of academics, practice, litigation, and so on. A very warm welcome to all of you. Before I am just starting, here is the title slide. That is, today's session is all about what are the general principles of the criminal law under the BNS 2023. So in the today's session, I'm gonna discuss that what are the general principles that are being enshrined in the new laws enforced as the criminal law enforced in our country from 1st of the July 2024. Before we move further, that what the law says, so what are the provisions that are being embedded in the law, what is the uniformity, what is the reformative measures, what are the preventive measures to just corrupt to stop the corrupted crimes and all. I would like to start the session with a few introductory words, as I mentioned upon the slides also, but those are not sufficient enough to start the session. So as we all know that there are certain transformative changes that are being made in the legislative landscape, and those requires each and every person, either it is the judge, either it is the stakeholder, either it is the academician, any of the law student, or even of the common layman or the Aam Aadmi, just to equate themselves with the new laws. What are the nuances in the administration of the justice? So to address this need, the Just Corpus in collaboration with me just held this session. So as we all know, India is the cusp of the seminal changes in the administration of the criminal justice system. The triumvirate of the laws, namely the IPC, that is the IPC 1860, Code of the Similar Criminal Procedure, that is the 1973, and the last not the least, the Indian Evidence Act, that is the Indian Evidence Act 1872. So these are being reformed, the backbone of the criminal justice systems is the colonial times, that are being replaced by the new three laws that named as the Bharatiya Nyaya Sanhita BNS, and the Bharatiya Nagrik Suraksha Sanhita BNSS, and the Bharatiya Sakshya Adhiniyam BSA respectively. And now these all the three major criminal laws came into effect from the 1st July 2024. So today's discussion is all about that what are the transformative changes being made under such laws and under the legislative landscape, why there is a need to that we have to just replace those colonial laws. And the session will also deals with what are the fundamental changes being made to address all the laws, or the to address all the nature of the crimes that are being evolved in the society nowadays. As we all know, when we discuss about the new criminal laws, then comes in our mind, okay, IPC is changed, CRPC is changed, and the Indian Evidence Exchange. So there we can say that the whole of the criminal justice system got a reformation now in that aspect. So we will discuss about each and every aspect a little bit, but in the for the BN in the today's session for the BNS, I will try to cover most of the aspects that are being changed. As I mentioned upon the slide also, there are few examples that being made the bring the reformations also for the same. That is, for example, offenses against the women and the children. Those offenses are being clubbed together, put together. They are being held with the chronological precedences, presumably to emphasize their relevance also in the combating crime. Now there are another thing that is being organized crimes that are which under various state laws and various various other provisions, like the new laws, like the new offenses like the mob lynching, snatching, terrorist, that also be punishable under the general law. So these are the simplest and a very specific basic thing that are being introduced. Now we discuss about the another aspect, that what are the changes are being made in the BNSS, that is replacing the CRPC, and what are the changes that are being made in the Bharatiya Sakshi Adhiniyam, that is replacing the Indian Evidence Act. So I will like to give you a glimpse or insight of the same also. As I have earlier already discussed that in the today's session, I will try to focus upon the one aspect, that is the Bharatiya Suraksha Sanhita, that is Bharatiya Nyaya Sanhita, sorry, BNS, that is replacing the IPC. But before moving further to the Bharatiya Nyaya Sanhita, that is the BNS, I would like to give you the glimpse that what are the major changes, or we can say what is the one line say for the reforms that are being made under the CRPC. Also under the CRPC, that is being replaced by the BNSS, the primary emphasis is in the new procedural law is the is like that timely justice and the use of development that are being there in the forensic science and the electronic communication investigation and for the prosecution of offenders. Now the changes are that are being made under the BNSS will provide a well-defined timelines at each stage for the criminal proceedings and much needed statutory negotiation of the use of the forensic tools, electronic communication, use of the audio video means during the investigation, servicing of the services of the summons, also supply of the documents, trial and the other proceedings. Now the adjective law under the criminal law is the Indian Evidence Act, that is being replaced by the BSA, Bharatiya Suraksha Adhiniyam. And now what is that? That where there are certain substantial changes and they gone through the Indian Evidence Act, that is particularly with regard to the electronic evidence that is being replaced the Indian Evidence Act earlier. Now there are certain parts that are also highlighting the enlarged ambit of the primary or the secondary evidences in the relation to the electronic evidences. So it clarifies also the statutory provisions in the vexed area regarding the admissibility and the certification of the electronic evidence. So these are some of the aspects that will help you sincerely will help you to understand or to assist you all uh, just that what are the changes that are being made. Now we comes to the what's the today's aspect is, or what's the today's session is all about. So as you all know, today's session is all about what are the provisions that are being made under the BNS BNS 2023. First of all, jumping into the directly into the provisions, I would like to discuss that statement and the of objects and the reasons. So, highlighting the statement of the objects, highlighting the reasons. There we can say that this is a particularly compilation of the fact that we are studying. Like first of all, it's a simplification of the legal complexities by streamlining the provisions that are related to the offenses and the penalties. Simplification is there now. The when there was a earlier there was a problem in understanding what the law is trying to say and how we have to do the interpretation. Now the words are keeping in a very simplified manner. Another thing is that for the petty offenses earlier in the IPC, no as such a provisions were there. So now for the petty offenses like snatching and all, so then for that community services are being introduced. Fine and punishment is also enhanced. Now when we discuss about the fine and the punishment, then under various laws, under various provisions, the fine and the punishment are being enhanced also and are being decreased also. So when we discuss about each and every section, that I will discuss make you available knowing that what are the changes being made there. Another very important aspect, and everyone is discussing about the same, that is the offenses against the women and the children. Now when we discuss about offenses against the women and the children, there is a chronological precedence being made, means that all the offenses that are being committed and that are being punishable under the IPC earlier or now under the BNS, they are being compiled comprehensively all together, and so that there is a chronological precedence. Now there are some of the offenses that were not gender neutral in the IPC, now have been made gender neutral. Another category of offenses like a severity kind of a category, heinous crimes, terrorist attack, organized crimes, or a kind of a petty offenses or offenses against the state are also introduced with the deterrent punishment. So these are some of the statements of the object, some of the reasons for which the BNS 2023 being introduced, and those are highlighting the reasons and the objects that why there is a need for the reform in the criminal justice system. Moving forward to the same, there are salient changes that are being made, because as a law student or belonging to a law fraternity, it's very important for us to just go through that what are the changes being made, and when we discuss about the comparative study. And for that, I think every student or the every person who is listening to me right now, kindly make sure that start reading the old one first, then go with the new one first, or start reading both all together, because before not knowing the older one, you can't understand the new act, and it will make you easy only just to compare, just to go through the facts, just to make acquainted with what the law is trying to say and how the law will work. Now regarding the salient changes, I have made a list and I will discuss upon each of the aspect. Either it's the scheme, either it's the definition, either it's the punishment, either it's abatement from the abroad, offenses against women, child, human body, state, and property. Now this is the compilation. If you anyone want to take the screenshot of the same, or I will share the PPT. So these are the particular categories under which under the BNS 2023 as compared to the IPC 1860, the changes are being made. Now, if any one of you are already having the BNS by Bear Act with you, then start open your Bear Act, and we will go through the index first, because before knowing anything in the law, what is being mentioned, we have to go through the index. Then only most of the things will be clear, and our mind will be like, okay, this provision is mentioned in this section, and this provision is mentioned with this punishment. Earlier punishment was this, now under the BNS punishment is this. So it's very important to go through the index. When we start with the very first aspect, that is the scheme. Now scheme says what? The Bharatiya Nyaya Sanhita is consisting of, as we all know, 358 sections. Now that is the 358 section, that is a streamlining version over the what the IPC, that is containing the 511 section. So it's now convenient to just acquainted with the 358 section as compared to the 511. I already know that being a law student, every section you need not to prepare. Every section that is being mentioned, provision being mentioned in the BNS or IPC, you didn't prepare. You just prepare a selective portion that is being as per your syllabus. But when we discuss about comes to the litigation, or either we join the judiciary or something else, then go for the litigation practice and all, then we don't know na, that what kind of a case we're gonna have, or we gonna have the litigation in what kind of aspect. So we have to acquainted with the 358 sections all together. So this is the scheme of the act. Now comes the new offenses. Before moving further, I would like to make you clear each and every aspect that I have mentioned upon the slide. That is the first thing is the definition. When you open the BNS Bear Act, then you will definitely see by yourself that the chapterization, the sections under the chapters, the content of the chapter, that are being made to a very particular, peculiar manner to prepare, just to make acquainted each and every person with the same law. For example, regarding the definition part, we can say that the definitions were just in a very vast manner in the IPC. Now when we discuss about the BNS, then there is a progressive change that is being brought under the Bharatiya Nyaya Sanhita 2023, that for example, under the section number 2 clause 10, the definitions are being made available very comprehensively, where when madam please Madam, please speak slowly. People are mentioning in the chat on the YouTube. Oh, sure, sure. Actually, there is a lot more to discuss in a very particular time limit. So I am just going fast. We'll try to. Okay. So just keep the Bear Act index open with you, and you will acquainted with what I'm trying to say. Now I just started with the definition only. So just and we have to discuss the act. Now when we discuss about the definitions under section number 2 clause section number 2 clause number 10, there is a new aspect is being also deal. There are some terms that are being also introduced. For example, the first word is the gender, that is being now we can say that the word is being now stated like pronoun he, that is being now the pronoun he and derivatives for the person being used, whether male, female, or the transgender. So these are the another, there is another term, that is the child, that is being defined under section number 2 clause number 3 of the BNS. Another definition is of movable property. You can mark in the Bare Act also either definition of the gender, that is now including any person who is just either male, female, or the transgender. Another definition is the child. Another definition is of the property. And there are certain changes are also being made. For example, archaic words like the queen, like the British India, like the servant, like the government, like the India, government of India. So these kinds of words are being deleted from the BNS, and now that is replacing the IPC 1860. The first aspect, that is the definition, we have discussed. Now we will come to the aspect, that is the punishment. So punishment, in the category of the punishment, there is a new form of the punishment, namely community services. I earlier also said that there is a new form of a punishment, community service, that is being added. Now, a punishment labeled as the community services will be awarded under the Sahita, and there is a category of the offenses for whom the punishment like the community services will be awarded. Under the section number 4 clause F, the community service is being introduced. I'm repeating the section, it's section number 4 clause F, the word community service is being introduced. There is a list of the offenses also, I mean to say sections also, where the community services has been awarded to the accused. Now, before jumping into what are the sections there, first of all, you must be acquainted with what the term community services says. So community services means a court itself order the work that is for the benefit of the community, and that work will benefit the community, and which is not entitled any of the remunerations. For example, the accused will be awarded with the sentence, ordered with the work sentence, that he would have to work the something, or for the, and that would be work would be beneficial for the society, for the community, and for that work he would not provided a penny, not a nothing like that. And the explanation of section number 23 of the Bharatiya Nagrik Suraksha Sahita, in the state, in the, there is a case also, that is the state through PS Lodha Colony, New Delhi versus the Sanjeev Nanda case. I will share the notes of the same, this thing that I have mentioned and read also somewhere. In that case, that is also known as the BMW hit and run case. I think everyone must be acquainted with that case. The Supreme Court also directed the community service under the article number 142 of the 142 of the Constitution of India as the reformative measure, because Supreme Court also stated that this is a reformative measure along with the payment of the compensation instead of enhancing the sentence. So there is a case law also for the same community service. And under the section number, another section is there, section number 18 clause C of the Juvenile Justice Care and Protection of the Children Act 2015. A juvenile also may be sometimes directed to undertake any of the community service as a penalty. So these are the some of the aspects that we can discuss regarding the punishment for the community services as being introduced. Now comes what are the sections, in which sections the community service has been introduced as the punishment. Particularly this is introduced for the petty offenses, and the sections name I am telling, and kindly mark in the index only. It's section number 202. Section number 202 talks about public servant engaging in the trade. Next is the section number 209, where there is a non-appearance in the response to the proclamation, that is the section number 209. Another section is section number 226. Section number 226 is like attempt to commit the suicide, to compel or to restrain exercise of the lawful power. So that is the section number 226. Another section is section number 303 clause 2, that is subsection 2, sorry, theft value less than 500 rupees, 5,000 rupees, where the theft and the values of less than 5,000 rupees, then it's section number 303 subsection number 2. Another section is the section number 355, that is appearing in the public places under the intoxication. So that is also being awarded with the punishment of community services. Now is the section number 356 that talks about the defamation. So and that section also, the punishment of the community service will be awarded. So these are the particular sections that we can discuss, that we can say that the community services will be awarded to the accused. Now comes the another part, that is the abatement from the abroad. I have mentioned upon the slide also, abatement from the abroad, where a new offense has been added under the section number 48 of Bharatiya Nyaya Sanhita. You can open the index, check the section, and I prepare it at randomly only. Okay, 40 at section number 48. Okay, new offense is there. That is what abatement from the abroad. So section is prepared all just in a second, which punishes any of the person. And in this section, any of the person is also included the foreigner, and who while being outside India, or if outside the India abets the abets the commission of an offense in India, then he would be get punishable under the law, and the law is section number 48 of the BNS. There are certain other sections also, and there are certain other aspects also. Now the another aspects talk about what offenses against the women and the child. One of the unique feature of the Sanhita, we can say Bharatiya Nyaya Sanhita BNS 2023, is the incorporation of the offenses that are against the women or either against the child into a particularly a very new chapter. That chapter is chapter number 5. You can open the index once again, go to the chapter number 5 and see what's the preamble of the chapter is. It says about the offenses against the women and the child, which has been given the we can say chronological precedences over the offenses against the human body or all other major offenses. So it's a very reformative kind of a thing, that chronological precedence is given over offenses against the human body or any other major offenses. Now, and there is a provision like for example, the definition of rape that is given under the section number 375 IPC. I think every law student must be acquainted with, is more or less replicated under the section number 63 of the BNS. Save and except there are certain modifications also in the exception number 2. What we can say is whereby exception is made applicable to the sexual intercourse, or the sexual acts also between the man with his wife, provided that she is 18 years of age or above. Now this change in the particularly the statute in the synchronization with the law that is being declared by the Honorable Supreme Court, and the case law is Independent Thought versus Union of India and another. So there are certain provisions for that also. Now we discuss comes when we come to section number 69 also of the Bharatiya Nyaya Sanhita BNS, that has been incorporated, that also is just talking about the penalizing sexual intercourse by employing deceitful means, or by just false promises of an employment, false promises of a promotion, inducement, marrying after suppressing the identity, or by making promise to marry without intention of fulfilling the same. This offense is always overlap the with the offense of the rape, that is the sexual intercourse that without the consent, where the consent is the vitiated by the misconception of the fact. That is the section number 63, that must be read with the section number 28 of the BNS. Now there is another aspect also of the criminal reformatives, that is the offenses where the gender is the offender, gender of the offender is no longer relevant. This is a very important aspect, where the gender is not relevant. For example, I will give you the insights of the 2 to 3 sections where this thing matters. Now, under the section number 78, if you go through section number 78 of the BNS, either talks about the assault or the talks about the criminal force to the women with the intent to just intent to disrobe. Then the word any man any man means, as was used in the corresponding sections 344B and 354 CIPC, has been repealed, particularly by whoever, thereby creating liability of any person irrespective of their gender. So the word whoever is just whoever replacing the word any man. There is another section also for the same concept we can discuss, that is regarding the gender of the victim is no longer relevant. For example, section number 96 of the BNS, that is the procuration of the child. For that section also, Another section we can discuss upon the same is section number 141 of the BNS, that is the importation of the girl or by from the foreign countries. So these are some of the provisions where gender of the offender is no longer irrelevant at all. There are another sections also that is being section number 95. Yes, you can't forget to discuss that also. Section number 95 particularly creates a new offenses. That's it talks. Section number 95, just open in your bare act and check. Section number 95 says what? Section number 95 says that new offenses that is being penalizing the hiring, that is being penalizing the employing or engaging a child to commit an offense. So that is being attracted under section number 95. Another thing, the aspect that we can discuss about is the unnatural offense. Unnatural offense, for example, say section number 377 is being already deleted because declared unconstitutional by the Supreme Court. Now the decision was just not only decriminalizes the sexual intercourse act as it was declared unconstitutional under the Navtej Singh Johar and others versus Union of India. Adultery, that is also being removed, that is under the section that is declared unconstitutional, Joseph Shine versus Union of India. Now comes a very important aspect, another aspect, that is the offenses against the human body. In the category of when we discuss about the offenses against the human body, now it's just like we can say that in the offense of a murder, a subcategory naming a mob lynching. Mob lynching is also being introduced. Mob lynching occurs when a group of 5 or more people, as per the law of the BNS, either it's a group of people that are being in number either 5 or more than 5. Then what happened? Persons act in the concert to commit particularly a murder on the ground of race, we can say caste, community, sex, place of birth, language, or personal belief, or any of other similar grounds. So punishment for each of the member would be of such as the group is equivalent to murder. And then that the section number 103 of the BNS will be applicable. So there is an introduction to the response of the directions that are being given by the Supreme Court for the mob lynching, and there was a case law also for the same. And the case law is Tehseen S. Poonawalla versus Union of India and others. In that case, Supreme Court issued the directions for the mob lynching, and also those directions are being introduced as a law under the BNS. Another thing is causing the death for the negligence. I think everyone must be acquainted with the same. That is the separate punishment now for the different category of the negligences. Now the separate category being made. For example, any person other than a registered medical practitioner under the section number 106 subsection number 1, imprisonment of either description that may extend up to the 8 years. Now another aspect is when we discuss about attempt to commit the suicide. So when we discuss about attempt to commit the suicide, section number 309 has also been deleted in the Sahita. And there is a thing that is being keeping in the mind, that the direction of the Supreme Court in the under Ramchandran Shaunbag versus Union of India and others under the section number 115 of the Mental Health Care Act 2017. But there is a new offense that is being added under the section number 226. You can open the index and check the section number 226, that is particularly penalizing the attempt to commit the suicide to compel or restrain the officials or just to do official duty. There is another new offense category, that is the new offense, that is the organized crime that is involving the continuing criminal activity, including the kidnapping, or we can say including the robbery, vehicle theft, extortion, cyber crime, trafficking of the people's drugs, weapons, illicit goods, services, that is by the 2 or more person is made punishable under section number 111. Those type of offenses, organized crimes, are being made punishable. So regarding the another category, that is the very important category, that is I also mentioned act endangering the sovereignty, unity, and the integrity of India, offenses against the state. Okay, so sedition, that is we all acquainted with the term sedition, that is the under section number 124 of the IPC, I think. Yes, under section number 124 of the IPC, A of the IPC. now being deleted. But section number 152 of the BNS has been added, and that is added as a new offense that would punish all the we can say occasions and the separatist activities, armed rebellions, subversive activity, any of the act that will endanger the sovereignty or the unity and the integrity of the India. And there is another provisions also now in the BNS, that is act of making or publishing any kind of a false or the misleading informations that are being having the tendency just to jeopardize the sovereignty, unity, integrity, and the security of the India or the country, has been added as the new offense. And the section for the new offense is the 197 subsection number 1 clause D. Another thing that is being made is offenses against the property, so house breaking, lurking, house trespass by night, section number 4 and 444 IPC, they are being deleted. Now the we will come to the another category, that what are the new offenses. So I have categorized all the new offenses, try to mention on a very one slide, that is mob lynching, discussed already, terrorist attacks, organized crimes, petty organized crimes, snatching, hiring, employing, or engaging a child to commit an offense. Either it's a sexual intercourse by employing the deceitful means, act endangering the sovereignty, unity, and the integrity of the India. And the another, last but not the least, that is the abetting commission of any offense in India while being outside the India. So this is a particularly a category of the offenses that are being newly introduced under the BNS, either on the recommendations of the Law Commission, either on the guidelines by issued time to time by the Honorable Supreme Court in different cases, or either according to the need of the time, that okay, that these offenses need to be penalized now. So there is a change, and for that reason, for this the compilation, the new criminal laws are being stated as the major reform. Now comes, I have mentioned upon the another slide, that is what are the offenses that are being repealed. Repealed means either the Supreme Court declared them unconstitutional, or either those have left no relevancy to discuss nowadays. But on the another hand, another offenses that are being committed with the severe heinous nature, that are being introduced. For example, unnatural offenses, for example, as offenses like the adultery, attempt to commit suicide, sedition, lurking, house trespass by night, house breaking by night. So these are the particularly offenses that are being repealed for the same. Now when we discuss about what are the major reforms being made, so we have to go through a particularly list of the aspects and the concepts. First of all, the major reforms, because the new law is applicable now, so the one thing comes in mind, that okay, now these are offenses you have repealed, fine, these are the offenses you have add on, fine. But is there any major reforms in the enactment? Is there any colonial law that is being reformed now? So yes, in the reenactment, the following is the list of the reforms major, particularly for it. The first of all is the offenses against the body. Offenses against the body, there is a major criminal major reform in the law. The death caused by the negligence, there is a categorization. Sexual offenses against the women, there is a categorization once again. What's the intention, what's the nature, what's the severity of the crime. Sedition, now that sedition as a crime being deleted, but now another provisions that is being threatening to the sovereignty, integrity, and the unity of the country, safety and the security of the country. So new offense being introduced. Terrorism is a particularly that is being included, and now in the act, just to intend the protect the country and just to penalize that who are being associated with these activities. Bomb lynching, already Supreme Court has issued the guidelines, so there is a need for the guidelines to make the law and make applicable. Community services, community punishment has been added, like for example, I have discussed earlier the sections, that is the 202 section number 209, section number 226, and so on. Another thing is this adultery and the unnatural offenses. Adultery and the unnatural offenses are the offenses that are being removed because the Supreme Court declared them already unconstitutional. So, my dear students, these are the some of the particular reforms that are being made under the BNS Bharatiya Nyaya Sanhita. If anyone having any doubt, any questions, please feel free to ask me, because it's not a one-sided conversation. You can ask me as much as the questions you want to, and I am here to answer you in my capacity to the fullest. Please, your suggestions and questions are most welcome, because I just want to clear the doubts as much as possible regarding the major reforms in the enactment, regarding the major laws. Yes, please, Kamlesh, is there any questions? Then please let me know. Kamlesh, kindly unmute yourself. I think.
Yes,
Uh,
ma'am. Ma'am, am I visible and audible now?
yes, yes, you are absolutely
Yes,
fine,
ma'am.
audible.
Thank you, ma'am, for the today's session. It was the wonderful insight.
Thanks.
We'll be taking the today some question, and I also invite participants to engage in the question and answer round, where you are free to ask question to Shivani, ma'am.
Yes, please.
Ma'am, yeah, ma'am. The first question what we got through the participant was, how do new criminal law change the present legal scenario?
Okay,
Means, yes, ma'am.
okay. The
Means it is how the new criminal laws have changed the present legal scenario.
Okay, okay, okay. I would like to answer the question with the present slide upon the screen. Look, whoever asked this question, please go through the slide once, and you will see that there is a compilation of the offenses for the of the facts that are being making our criminal system more reformative. That is making more strengthen our criminal system, justice system, and I think the by making some of the acts as a punishable offense will make try to make the society in a very better way. The justice can prevail easily. For example, that caused by the negligence is all categorized. Sexual offenses against the women are being categorized. Now the sedition is now included with the more improvised provisions. Now the community services has been added as a reformative for the punishment. There is a mob lynching now is a punishable offense. So there are certain aspects, and I want to discuss these offenses also with the on the mentioning upon the slides, like the mob lynching, organized crimes, snatching, or any of the other crimes getting abetting commission by any other offenses in India while being outside the India. So these are the categories now that are being just on the way forward, just to make the criminal justice system more reformative. What else one need? Since a month before, there was no as such reforms were there. We are just living with the colonial system, with all those old laws. No as such law. Daily new provisions are new acts are being doing, new crimes are being committing. So there is a need to now, and these compilations of both the slides, I think, answering the question very well. Yes, please.
Thank you, ma'am. We'll be going with the second question, which we got. The question is, what is the impact of new criminal law on the society right now?
Regarding the impact of the new criminal laws on the society, it's very early to answer this question. The impact we can assess either a year pass or the time passes, and the accused being get punished in a way they deserve that to be punished, and the victims prevail the justice, avail the justice. Then we can say okay. And regarding the assessment, yes, the reforms will definitely bring the positive change. Always looking forward, and I think give some time to just assess the. It's very early to answer this.
And now, ma'am, the third question is very interesting.
Yes.
The third question is, why they didn't mention the marital rape in the new criminal law?
Whose name? Sorry.
Why they didn't mention the marital rape, the term marital rape in the new criminal law?
Okay, okay. Actually, in India, in our country, in our society, we are living in marriage is a sacrament. It's not like that. Okay, the things happen, and being a sacrament, there are other customary laws associated with the same. The Law Commission, the Honorable Supreme Court, the lawyers, the researchers are doing the work upon the same. And if of the situation worsens, then no one knows that the law will be there. always hoping for the best and finger crossed that the situation extent.
Yes, ma'am. Ma'am, the fourth question. Thank you, ma'am. What is the ma'am? The fourth question for this today's session is what are the key principles and the procedure governing bail in India, particularly in the case involving serious offences?
Okay. For the bail you are asking now, for the bail there are certain amendments being made, but the provisions that are being laid down in the CRPC that are being much followed for the bail. So there is no as such reforms in the bill. As for now, the provisions are somehow copy pasted for with the same old one.
Thank you, ma'am. Ma'am, the fifth question is will the introduction of these new criminal law will diminish the role of amendment in the Indian legislature, as any government with a strong majority can easily introduce new laws altogether rather than work upon the existing ones?
Look, there is a political touch also in the question, and as a law student, as a law fraternity, we have to just rally upon what the law says so, and how the justice can be prevail. What the government, and actually, the government doesn't have the liberal power to just change the law every minute. Till now the governments have changed so many times, so the constitution must be changed so many times. It's not that easy, and just please relax and just focus upon what the law is saying and how the poor person or how the needy person can access the justice. We must focus upon the same, because I don't want to make the discussion to a political thing. Yes.
Thank you, ma'am. Ma'am, this next question is:
Yes, please.
were these laws really necessary?
Sorry, what does the
Were these new laws really unnecessary?
yes, really necessary from a since a long time. The reforms is actually needed. Actually, in the year 2010, there was no such tech or AI was there. But now there is a need of the artificial intelligence also, technology also. So in the same manner, if the society is progressive, so the reforms is needed. And the very optimum time, the reforms are being in the applicable state now, enforced in the form of new criminal laws with the
Thank you, ma'am.
development and the progress of the society. Yes.
Thank you, ma'am. Ma'am, the next question is: being from the perspective of law student who hasn't got through the old laws, who hasn't gone through the old laws, how should we tackle both old and new laws together? New and
Okay.
old laws.
Okay, this is the question of many students who are just new into the law. They are just like, okay, took the admission this year or the last year. They are just like, okay, we have to study the old. But start preparing from the old law. First, read the old law, then read the new law. Then you will basically try, in the capacity to compare and to get acquainted with the laws effectively. Okay, the what's happening in the past and what's the happening now is the aspect. Now you have once you just gone through both the laws, then only you will make to the mind prepare for the self. Okay, these are the needs for the changes or the reforms required. So study of the both laws is required. Is there any other question?
Yes, ma'am. The last question.
Yeah, please.
Uh, yes, ma'am. Ma'am, the last question of this today's session is: how will the new laws affect the workload of court and law enforcement agencies?
Look, you have clubbed two questions. First of all, the pendency of the cases, workload of the judiciary is the another aspect, and new law is the another aspect. New criminal laws are for maintaining making the access of the justice to the each and every person, and workload of the judiciary is the another aspect. And yes, the we can say the trial process are being made to the ease, so the early justice may be accessible. So yes, it will definitely reduce the work of the judiciary and all, rather than the
Thank you.
issue. Yes, thank you so much. It was
Thank
really
you, ma'am.
interesting session.
We'll be proceeding towards the final vote of thanks.
Thank you.
In closing, we extend our heartfelt gratitude to Miss Shivani ma'am for accepting our invitation and delivering such an informative session. We trust that the audience found it both interesting and knowledgeable. Thank you once again, ma'am, and we eagerly anticipate the opportunity to host you again. Thank you, ma'am.
Thank you. Thank you, Just Purpose. Thank you, everyone. Goodbye.